Sawadee-ka. First of all, I want to say thank you for you all being here today, and especially thank you to the Dean and the Vice Dean and the faculty and staff that have been putting on this presentation. Thank you so much. It's a privilege and an honor for me to be here today from the United States speaking to you. So, as my brother John said, the focus, my focus is a very narrow focus. I'm a criminal defense attorney. I defend people accused of crime, and we work within the jury trial system. When I first started practicing law in 1979, when I got out of law school, I was immediately thrown into the jury system. I worked at the DA's office, the prosecutor's office, and so to me, my whole life as an attorney, all I've ever known is jury trials. Now, you don't have jury trials in Thailand, but you've seen juries on TV and in the movies and in books, so you know what it is. It's basically, it's an odd concept. You know, we have lawyers, we have judges, we have police officers, and then all of a sudden we basically get 12 people off the street and bring them in and say, okay, you decide our cases for us. So it's kind of a weird concept to wrap your mind around. But to people like me and people who take the job really seriously of being a criminal defense attorney, it's a sacred trust. You have somebody's life in your hand. As my brother mentioned, last week I tried a case. It was a case my client was charged with aggravated kidnapping, and he was looking at life imprisonment. It was a first-degree felony, one of the highest offenses you can be charged with in Texas. And you know, it's kind of stressful. I was the only thing standing between him and being convicted, and you really have to research the case and know the case better than the other side and really do a good job. I mean, somebody's really depending on you. And famous defense attorney in the United States, his name is Clarence Darrow, and you might have heard of him, but he basically said, you know, criminal defense attorneys are some of the most reviled and hated people in the world, because you're basically representing, you know, people accused of the worst crimes imaginable: child molestation, murder, rape, things like that. So, but then on the other side, you have this client who's depending on you to help him, and you know, he might be wrongfully accused. The state or the government might be overreaching, or might have even committed some violations or crimes during the prosecution, and you really have to. And they don't like it. They don't like it when you win a case. They didn't like it when I won that case last week. My client liked it, and his family liked it, but the prosecutor and the police didn't like it too much. But that's the system. It's win or lose. Now in Texas, you can get a jury trial for just any crime imaginable. If you're driving down the street and a police officer pulls you over for speeding and gives you a traffic violation, you can have a jury trial on that. And usually for the lower level crimes, what we call misdemeanors, we have 6 jurors. And for the higher level crimes, which we call felonies, we have 12 jurors. And sometimes they pick alternate jurors in case one of the jurors gets sick or dies during the trial, so it doesn't result in a mistrial where they have to try the whole thing over. They'll get 1 or 2 extra jurors and call them alternates. And we had last week in the jury trial we had 2 extra alternates, so we had 14, and at the time the case was over and the jury went into the jury room to deliberate, the 2 alternates were dismissed. And the 12 got to decide the case. And also a weird thing in Texas, this is kind of more just Texas law than any other law. In Texas, you can also have the jury assess your punishment. So in case the jury does find you guilty, you have an election to make. You can either ask the judge or you can ask the jury to assess your punishment. And you have to be psychological, and you have to be like a giant chess match. You're playing a giant chess match and you have to think 3 or 4 steps ahead. So then you have to decide, well, what do I know about this judge? Is he a fair person, or is he going to really hammer my guy for as many years as he can? In Texas, our judges are elected. We have elections for judges. So, you know, not necessarily the person best qualified becomes a judge, but the person who's the most popular or wins a popularity contest, like in high school. So a felony judge for the higher crimes, every 4 years he has to be reelected again. So a lot of times their thinking is, well, I want to keep my job, and the way you keep your job as a judge is you're tough on crime. So if you're in a court like that, you're going to elect to go to the jury for punishment. And but the other consideration on the other side is sometimes this jury that you're asking for punishment is the one that just found your client guilty. So you really have to make a choice. Now, of course, if your client is acquitted, like my client was last week, it's a moot issue. You don't go to punishment. It's over at that point. And basically the way we get the jurors, it used to be in Texas that when they had a trial at the courthouse and they needed a jury, back in the old days of the cowboys in Texas, you know, cowboys and Indians, everybody had horses and cowboy boots, they would actually send the bailiff. The bailiff is a court officer, like he provides security for the courtroom. They would actually send the bailiff out into the street to round up the first 12 people that walked by and bring them into court and say, okay, here's the case, you decided. Now it's a little more sophisticated now. They use voter registration lists or property ownership rolls and things like that. So that's where they get the names, and then they get the person in. But juries are so important, and I'm gonna give some examples about some of the concepts I'm talking about. You all might have heard about that case in Aurora, Colorado, where the gunman shot up the movie theater. It was a few years ago. It was during the Batman movie, when the Batman movie just came out, and it was the first day the movie showed, and the theater was really crowded, and a gunman came in there and shot a bunch of people. And you remember that? Well, recently they had the trial, and it was a jury trial, and this was in Colorado, not Texas, but I followed it. And in Colorado law, the individual who shot up the movie theater, he used the insanity defense. And he was found guilty. But when you get to the punishment stage of the trial in an insanity defense in Colorado, usually a jury verdict has to be unanimous. In Texas, all 12 jurors have to agree that the client is guilty. Otherwise, he's not guilty. But in Colorado, they have a weird little quirk in the law on the punishment phase of a murder trial like that. The jury has to reach a unanimous verdict, or it's not a mistrial. In Colorado, what happens if the jury can't reach a unanimous verdict at the punishment stage of a murder trial? That means the person automatically gets life imprisonment, and the death penalty is no longer on the table. And that's what happened in that case in Colorado. One juror, that's how important juries are. One juror, not an attorney, not a judge, some person off the street who came in to be on the jury. One juror said, I don't think he should get the death penalty. I think even though we ruled against the insanity defense, we think he's mentally ill. I think he's mentally ill, just one person. And he says, I'm not voting for death. So it was 11 for death, 1 for life. And under Colorado law, that means he got life. That's how important juries are. And in Texas, what we have is, if a jury's back there deliberating the case, and they send a note out to the judge and say, Judge, we're deadlocked. We cannot reach a unanimous verdict. The judge will say, okay, go back and deliberate some more and see if you can do it. And if they come back again and say, we still can't reach a unanimous verdict, the judge will give them a new written instruction telling them what the law is. And it's basically what we call an Allen charge, or a dynamite charge, which is kind of like you want to set off some dynamite under the jurors and make them decide. And it basically tells them, you know, we've spent a lot of time here. We really need you to make a decision, but don't violate your conscience. But we really need you to decide, and if you can't reach a unanimous decision, we have to retry the case all over again, and there's no guarantee that the next jury is going to get any more information than you did. And then if the jury comes back at that point, after the Allen charge, after they deliberate some more and say, we still can't reach a verdict, then it's a mistrial. And there's certain things that happen during a trial that will decide if it's a mistrial, whether the state can retry the case again or not. Sometimes they can't, most of the time they can. And we also have in Texas what we call when you get to pick the jury. So like for instance, last week, we had 120 jurors come in the room. The judge got 120 jurors in, and then all the attorneys are allowed to question the jurors to find out what their qualifications are, to see if they're disqualified from sitting because they can't be fair, they can't follow a certain law that's applicable to the case. Or we also, each side in a criminal felony case gets 10 strikes, where you can just strike 10 people that you don't want. So eventually we take this group of 120, and the first 12 that are not either disqualified for cause or stricken by a peremptory strike, they get seated as the jury. Now in federal court, John told you about the difference between state and federal court. In federal court, usually the judges do not allow the attorneys to address the jury at all. It really dilutes, it really takes away the whole idea of having a jury trial. There's no voir dire, so you don't have interactions, because when you're talking to a jury, when you're talking to 120 jurors, you're trying to find out what their qualifications are. You're trying to get the people off the jury who are not going to help your case, and you're also educating the jury and brainwashing them on how you want them to think about your case. This is what an advocate does. You know, in the United States, we have the adversary system. It's the prosecutor versus the defense attorney. They fight it out in court, and, you know, hopefully the best man wins. You've all heard the concept of there being a wrongful conviction. We have that a lot. I mean, you might have heard, you know, somebody's on death row for 20 years, and they get exonerated by DNA, you know, a scientific method that was not available when they were first tried. So it's really important to be a good defense attorney and leave no stone unturned when you're defending somebody in the United States. And this ties in with my next topic, which is a very important topic. It's called jury nullification. This is so important. Jury nullification is a concept where the jury actually ignores the law and protects the accused from a bad law. It's when juries ignore the law and follow their conscience instead. And see, this is one of the great reasons that defense attorneys would want to get a jury in to hear their case. And it's actually a reason why a lot of governments across the United States are doing away with jury trials. They're chipping away at the right to a jury trial. In some states, if you're found guilty, you automatically go to the judge for punishment. In some states, you can't get a jury trial anymore. I mean, they're doing away with it. And one of the things that they point to all the time is jury nullification. It's basically really the jury letting somebody who's accused go free to protect them from an unjust law. Let me give you an example. Or to protect them from overreaching prosecution. Let me give you an example from one of my cases. I was once representing a judge, a district court judge, a felony court, the highest criminal judge in trial in Texas. I was representing a judge who was charged with nepotism. Nepotism is where you hire your relative to work at your job. In Texas, it's a crime. You're not supposed to do that. But it's a misdemeanor. It's a very low crime. But if she's convicted of nepotism, even though it's a misdemeanor, she doesn't go to prison, but she's removed from the bench. She's no longer a judge. So they indict the judge, and the case is going along and along. And a couple of months into the case, the DA's office, the prosecutor tells us if she pleads guilty to the misdemeanor, we won't seek jail time. Like I say, prison time's not on the table. We will not seek jail time. She'll just get probation, but she'll be removed from the bench, but she'll still get to be an attorney. She still gets to keep her law degree and her law license. So she said, no, I'm not pleading guilty to anything. I want my jury trial. So we told the prosecutor she's not pleading guilty to anything. And the prosecutor said, oh, okay, that's fine. So then they take the exact same facts that she was charged with nepotism on, no new evidence, no new investigation, and they indict her for 4 new felony offenses, just out of the blue. Abuse of official capacity, bribery, I can't even remember what all the others. But this was a beautiful case for jury nullification. The jury, because all this came out during the trial, they didn't want it to come out, but I wanted it to come out, and it was a battle, but eventually it came out. And the jury was so mad at what the prosecutor did that they found her not guilty of everything, including the original misdemeanor that she was charged with of nepotism, which she was actually guilty of. They're like, at that point, they were punishing the government for doing what they did. So that's a perfect example of jury nullification. We also have a concept in criminal law in jury trials called sequestration. That's where you sequester a jury. Like if you have a jury, let's say it's a case of a nasty case, child abuse or sexual assault of a child or sexual exploitation of a child. It's very sensitive. People don't like it. Sometimes the egregiousness of the accusation itself will overcome the fact that there's not enough evidence. And it's a very, I mean, you're walking a fine line when you defend someone on that. So in a case like that, the jury, all they've heard for days is what happens in the courtroom. And then at the end of the case, when the jury gets to go back into the jury room to deliberate, let's say it's late in the afternoon, or let's say the jury just takes a long time to decide the case. They're in there all day, it's Friday night, it's 6 o'clock. Well, either side could ask for the jury to be sequestered. That means they don't get to go home anymore. They have to go to a hotel, and they're strictly monitored by the court's bailiff and the security team of the court, and they're not allowed to talk to anyone except themselves. So again, it's psychological. It's a chess match, and you have to be 2 or 3 steps ahead. So you have to decide when you ask for this. Oh, and the jury's not allowed to know which side asked for the sequestration. They're not entitled to know. So as a defense attorney, you have to ask yourselves, is this the kind of case that the jury, if allowed to go home for the weekend, they're going to talk to their spouses, their husbands and wives, their kids? They might read a newspaper, which they're not allowed to read, or somebody might tell them, I can't believe you guys haven't convicted this guy yet. Or it might be the kind of case where the public is on our side, but you don't want the jury influenced by any outside forces other than what they see in court, so you ask the jury to be sequestered. So that's a valuable tool. We also have a tool whereby I told you, you can strike, each side can strike certain jurors that they don't like from the jury, even if they are qualified to sit as jurors. Well, the exception is if it's the government that is striking people left and right, there's another remedy that the defense attorney has, and it's called a Batson challenge. So for instance, let's say I'm representing a black man. I'm representing a black man in a court in Texas, and there's maybe 1, maybe 2 jurors who are black on the panel of 120 jurors, and the DA uses 2 of his peremptory strikes. He doesn't have to give a reason on both of those 2. Well, the only exception to the rule that you can strike somebody for any reason is you cannot do it for racial reasons. You cannot do it because of prejudice and bias. So if that's the case and the prosecutor strikes the 2 black people on the jury, the defense attorney can say, Judge, I make what's called a Batson challenge, and the state has to justify why they struck those 2 jurors, and it cannot be a racial justification. And then the judge gets to decide. So that's another tool that the jury has. We also have a concept called, what we call it, running the panel, which means, let's say you get 120 jurors in the room, and it's a really nasty case, aggravated sexual assault of a child or whatever, and the jury, most of the jurors say, I can't be fair. I think he's already guilty. I haven't even heard the evidence yet. I don't care. I'm gonna convict. Well, if enough of them say that, and when all is said and done, you don't have enough, there's not even 12 jurors left, then a mistrial is granted in that situation as well, and in that case, the case can be retried. But as a defense attorney, it's a good tool, because if you can run the whole panel, every time you do that as a person representing an accused, what you're doing is you're sending the prosecutor away without a conviction, and your guy gets to go home that night. And if you keep doing that a number of times, you wear out the prosecution till eventually they dismiss the case or they offer you a better deal at plea bargaining. So basically, it's kind of a Texas saying, we're running the panel. In other words, we're running the whole panel, like we're running a flock of cattle. We're making them all go away, and we can't have a jury today. Because what happens in a trial is the prosecutor is there to convict my client and send them to prison for as long as they can. If I can run the panel and make it like there's not enough jurors left, we just don't have enough left, Judge. A way to get them a lot is, in Texas, we have probation. Probation means at the end of the case, you're convicted, but instead of going to prison, you're put on probation, which means you get to go home that night, but you have restrictions on you. You have to report to a probation officer, you have to do community service, pick up trash on the street or whatever. So a lot of times if you have 120 jurors and you have a really bad case, and you ask the jurors, okay, who here could not consider giving my client probation if he's convicted of this crime? And this is before they've heard any of the evidence. If all 120 jurors say, I'm not considering probation, I can't consider probation for a crime like this, they're all disqualified and you don't have enough jurors left, so you basically ran the panel and you sent the prosecutor home without a conviction, and they get to try the case again. So, for example, last week when I had 120 jurors, the defense attorney and the prosecutor are both given jury sheets that each juror had to fill out before they came to court. And we call them jury sheets. They ask them their name, their occupation, their spouse's occupation, where they went to school, if they've ever been on a jury before, if they've ever been the victim of a crime before, if they work for the police department, or they know anybody at the prosecutor's office, all kinds of questions. And you're given these papers. So we have last week 120 sheets of paper, and then when you do the questioning of the jury, you're allowed to, you already know it's in aid of that. So you have the piece of paper, and sometimes people will write things like occupation, retired. So then during the process you have to ask them, retired from what? Because you need to know that. Maybe they're a retired police officer. The defense attorney needs to know that. So the other thing that I wanted to talk about before I leave is the concept of a request for a directed verdict. This is in the middle of a jury trial. You have 12 jurors seated here who are going to decide the case, and the state rests their case. They've finished with their case. They called their last witness. They've rested. So now it's the defense attorney's turn to either put on evidence or not. They don't have to. It's up to the state to prove the person guilty. The person does not have to prove himself innocent. So at that point, at the point where the state rests its case and said, that's all the evidence we have, we're not putting on anymore, before it's turned over to the defense and the jury's sitting there, it's customary for the defense attorney to ask the judge, I have a motion to make. And that's a signal to the judge, and he gets the jury out of the room, so they're not allowed to hear this. And then you argue to the judge for what they call a directed verdict. You're basically asking the judge to direct the state out and say, you know what, judge? They did not present sufficient evidence to even allow the case to go to the jury. They didn't, they have to prove all the elements of a crime. They didn't present any evidence to prove this element or that element or whatever it is. And then the judge has to make a decision. If the judge says, I'm granting your motion, and I'm ordering a directed verdict in this case, that means your client is found not guilty and he can never be retried again. Jeopardy has attached. It would be a double jeopardy violation to ever try him again. If the judge says, no, I'm denying your motion, which is what happens most of the time. Most of the time the judges don't grant that motion. Every once in a while they do. Then if he says, I'm denying your motion, I think there is enough evidence for the case to go to the jury, then the jury comes back in, and you, as a defense attorney, you either rest and just go to the jury on a reasonable doubt defense and just say the state didn't prove their case, or you can put on your own case if you want to. Okay, that's about it. Thank you so much for listening to me and for your courtesy. Kap kun ka.